गुड मॉर्निंग. बोला की. बोला.
Vilas, VC sir is joining. Vilas.
Sir, okay, sir. Okay, sir.
Yeah.
Yes.
Acharyulu, sir.
Mr. Vilas,
Good morning, sir. Good morning.
good morning. What is the full name of the speaker?
Advocate Sambhaji Patil.
Sambhaji Patil.
Yes, sir. Yes, sir.
He's a advocate.
Yes, sir. Yes, sir. Also, he's a retired DYSP.
Okay.
Yes, sir. Yes, sir.
Okay. Has he come in line?
Yes, yes, sir. Sir has joined.
Yes, good
Okay.
morning, sir.
Good morning, sir.
I am Sambhaji Patil here.
Good morning, sir.
Thank you, sir.
Thank you so much to have your talk today.
Yes, sir.
We are grateful to you.
It is my pleasure, sir. Yes, last already informed me.
Yeah. You are most relevant speaker today.
Yes, sir. Yes, sir.
You have a lot of experience in the police department, a senior officer, and also in law. You are a specialist.
Yes, sir.
So our students and faculty are very fortunate to have you.
Definitely, sir.
Thank you so much. Thank you so much. Yes. Yeah, Mr. Vilas, please go ahead.
Yes, sir. Yes, sir. We're waiting for Acharyulu, sir.
Okay, we'll join. Please start.
Okay, sir. Okay, sir. Sure. Good morning, one and all present here. On behalf of Centurion University, Andhra Pradesh, and Centurion University, Bhubaneshwar, Odisha, I, Vilas Anil Chavan, would like to welcome you all for this today's webinar. Now, may I request to Colonel Professor Dr. GSN Raju sir to please address the web.
Yeah, dear colleagues and most respected Speaker Patil ji,
Yes, sir.
and other colleagues from Centurion University, Parlanchimudi and Bhubaneshwar. Good morning, all of you. I should say the Centurion University is very fortunate to have a great speaker today. Touch with you, please help us, guide us in this particular specialization. And the Centurion University, Andhra Pradesh, Vizianagaram,
Continue, sir.
very budding university. Came up in 2017, but however it is made. It is basically skilled university. We have well qualified faculty. Mr. Vilas is coordinator for all the campuses, and he is leading the department very well. And on this occasion, I welcome Mr. Patil ji. Please
Yes, sir.
to start a webinar. And Mr. Vilas, you continue.
Yes, sir. Yes, sir. Thank you very much, sir. Now we request Sri Vilas Chavan to introduce the chief guest of the day to the guest gathering. Vilas Chavan.
Sure, sir. Thank you. We have with us today Advocate Sambhaji Patil. Sir is retired DYSP, Maharashtra Police, as a guest speaker. Advocate Sambhaji Patil sir has received prestigious Police Medal for Quality Meritorious Police Service by the precious hands of President of India. He has also received various prestigious awards from Maharashtra State Police and Maharashtra government. He has got silver medal at All India Police Duty Meet 2015 in criminal laws and investigation procedure. Sir has delivered more than 500 lectures to various law enforcement agencies and universities. So that is the brief introduction of today's guest speaker. Over to you, sir. Acharyulu, sir.
Yes. Thank you.
Sir Patel ji, just 1 minute. Patel ji, I congratulate you for such a wonderful background of your profession.
Sir,
We are so happy to repeat to thank you very much.
thank you again, sir.
Thank you, sir.
So, good morning again to all of you, sir, and all my dear students. Can you listen to me properly?
Yes, yes.
Okay. So, it is my pleasure to be with you or to be among with you because I am still a student. Though I have been designated as advocate or DYSP retired, whatever it may be, but still I am a student at the age of 62 years. Yes, so you should be also, I mean, all students should keep in mind that we are students. We have to learn so many things, by the way. And today's my lecture topic will be a role of law enforcement agencies and forensics as experts in Indian justice system. So, according to, I mean, Indian criminal justice system or Indian judicial system, there are so many important, I mean, agencies take part in imparting the justice. But today's lecture is limited to us, especially it is regarding law enforcement agencies and the forensic science experts. So what are the law enforcement agencies in India? So first of all, I will explain you that the Constitution of India has 3 various lists, that is central list, state list, and concurrent list. Actually, the police subject comes under the state, I mean, list. However, there are some central level agencies which have also the powers of investigation or the enforcement of various laws. So I will take a brief, short discussion about the law enforcement agencies in India. First of all, as you are aware, that is CBI, Central Bureau of Investigation, National Investigation Agencies, Enforcement Directorate, then Narcotic Control Bureau, Income Tax, Central Income Tax and Customs and Excise, then CISF, BSF, and some armed forces have also powers of investigation, as well as GST, central GST officers have been also empowered with the new act of, that is GST Act, Central GST Act 2017. They have been also empowered to investigate certain offenses. Even Indian Forest Service officers have been also empowered to investigate certain cases, and then under Indian Forest Law, the Indian Forest Act, or the WPA, that is Wildlife Protection Act. And now I will come to the state agencies, state police agencies or some other departments where the investigation powers have been given to the various departments. In various states, the state police have also been empowered with the powers of investigation. However, the state reserve police forces like Maharashtra State Reserve Police Force or any other state reserve police force have not been given the powers of investigation. They are specially, recruited for the maintenance of law and order as well as public order. So state police have various branches like CID, Criminal Investigation Department, then Anti-Corruption Bureau of the state police. They have also powers of investigation. Then in the state, there is also another department, that is State Excise and Prohibition Department, which deals with the illicit liquor or the licensed liquor and their control, regulation, and all other licensing controlling authorities have powers to, investigate certain cases. Then Forest Department officers have also powers under this, investigation. So these are the state and central police agencies which have been implementing various laws. But most importantly, all the investigation agencies have to take or to conduct investigation as per the provisions under the Code of Criminal Procedure 1973. This is the most important act which deals with all criminal trials, all criminal investigations, that is all types of criminal investigation. Only some special acts like PMLA, Prevention of Money Laundering Act of 2002. This is, dealt by the Enforcement Directorate under the Ministry of Finance of the central government. Then there are also certain special laws. For example, CBI is, controlled by the Delhi Police Special Establishment Act of 1946. Like this, the various agencies of investigation of the center and state have also to conduct investigation only according to the provisions under CRPC. So what is investigation? This is also a very important point, because each and every student of the forensic science department, as well as the police officers or the law enforcement agency members, should understand what is investigation. So this definition has been given under the Code of Criminal Procedure, section 2 into bracket H. 2 into bracket H. What is investigation? So the definition starts by the word investigation includes all the proceedings carried out under CRPC by a police officer for the collection of evidence. Here, the word collection of evidence is very important, because the collection of evidence, the role of collection of evidence begins here, and this power is not only given to the police officer, but all the forensic science experts have been empowered to collect evidence and to assist the police officer or to give legal assistance in the process of investigation. So again, I will repeat the definition of investigation. Investigation includes all the proceedings carried out under CRPC by a police officer for the collection of evidence. And what is the final object of the investigation? To find out the truth in the incident or any crime. So final aim of investigation is to find out the truth in the incident, whether the offense has taken place or not, whether the incident has taken the place or not, whether particular accused is involved in this case or not, whether he is actual a suspect or whether he is an accused or whether he is an innocent. It will be decided only after the collection of evidence and the result of the investigation. So final aim or objective of the investigation is to find out the truth in the incident, and that is investigation. Now let us see, investigation is also, or it may be also handed over to any other private person by a judicial magistrate or any other higher courts to private person. For example, now I am a retired DYSP. Okay, Colonel Raju sir is also a retired officer from Army. Okay, if the judicial magistrate thinks that this case may be, handed over to the retired DYSP Sambhaji Patil, and he should be given powers of investigation, the judicial magistrate can give an order. And in India, there are two incidents. I will explain you, which I know, where the private persons were appointed as the chief investigation officers of the SIT. SIT means Special Investigation Team. You may remember the Gujarat riots of 2002. Godhra riots, and all over Gujarat, there were so many communal riots, so many killings from both sides. And the investigation was not, done properly, fairly, and impartially. So many people and the NGOs went to Supreme Court, and in Supreme Court has appointed a retired director of CBI, R.K. Raghavan sir. He is the most important and dignitary from CBI, independent, fair, and impartial officer. So he was appointed as the chief investigating officer of the all SIT in Gujarat. Various IPS officers and state police officers were taken from various states under his guidance. So each and every case was scrutinized by him, whether there is sufficient evidence to forward the accused to the criminal court was verified by himself, that is Mr. R.K. Raghavan sir, who was ex-director of CBI. So this was done under the provisions of CRPC section 2(h). So are you getting me properly, sir?
Yes, sir. Yes, sir.
Can you listen?
Yes, sir. Yes, sir. You're
Okay.
audible. Yeah.
Otherwise, if I am not audible to you, please I will. Okay.
Sir, we are getting your voice.
Yes.
Please continue, sir.
Yes. In
Vilas, please take
Maharashtra
care of
also,
the people who are
in
causing
Maharashtra
disturbance.
also,
Yes, sir.
there was one, a serious crime done by Telgi, Abdul Karim Telgi, and who has, prepared or forged various stamps and currency notes. And because of that, he was arrested, and it was very big economic scam or economic offense. And during that period, some officers who were investigating the case were also arrested for the connivance or criminal conspiracy or some acts of omission. That is why the retired IPS officer S.S. Puri was, now he is no more, but he was appointed as the chief investigating officer of the SIT for the Telgi scam cases. So these two examples are, I am very much aware of these two things. Then we should know the definition of, what is an offense? What is an offense or what is crime? So what is an offense? It is any act or omission. See, any offense is done by any act or by omission of also act, omission of lawful act. Then for which there is a punishment, imprisonment, or a fine. That is for the time being the law existing. So any violation of the existing laws for which there is a punishment or imprisonment or a fine for the act of commission or the act of omission also. That is also defined under section 2 into bracket EN of the CRPC. Then we have to also understand what is or who is a victim of the crime. The definition of victim is added in the Code of Criminal Procedure in the year 2009. Because this, total justice system is revolving along with the victim. Because the criminal justice system in India or the role of law enforcement agencies or forensic experts or public prosecutors or the judges or judicial system is to give justice to the victim. Then who is victim under this CRPC? So victim means a person. See, the person, word is used as person, who has suffered any loss or injury. Any loss or injury. Injury means there are 4 types of injuries: physical injury, mental injury, economic or financial injury, and injury to the reputation or to the particular, psychological injury. So, victim means a person who has suffered any loss or injury caused by reason of the act of or omission for which accused person has been charged, and the expression victim includes his or her guardian or the legal heir. If the victim is no more, if the victim is killed in the murder case or in dacoity case, then the guardian or the legal heir of that person will be also known as the victim. So the victim compensation system has been inserted under section 357 of the CRPC, and they are given certain, financial, aid for the rehabilitation of the victims. So our total criminal justice system or Indian judicial system revolves around the victim, and our aim should be to give justice to the victim. A victim means not only the person who has suffered a lot, but his legal guardian and his legal heir also come under the definition of victim. So please, understand these 3 important definitions, that is what is offense, what is crime, what is investigation, and what is, who is a victim in this case. Now, we will go again on to the next point, that is now what is the role of law enforcement agencies and the forensic experts. So investigation starts with the information to the police officer of a cognizable offense. Police have powers, police have been, recruited only for the purpose of investigating the cases or the crime which is a cognizable offense. What is cognizable offense is also defined under CRPC. Because non-cognizable offenses are not immediately investigated by the police officer, unless and until there is a permission from the concerned magistrate. Okay, so when any information in relation to a cognizable offense If given to the officer in charge of protection, he should record this information or reduce into writing, or under his guidance, he may depute any subordinate to reduce into writing. Then it starts with the section 154 into bracket 1 of the CRPC. That is first information report given to the officer in charge of protection about a cognizable offense by any person. Anyone can set law into motion. And the powers of investigation have been given under section 157 of the CRPC. Here, the role of law enforcement agency officers as well as the role of forensic science experts start. So please note down the section 157 into bracket 1 of the CRPC, that is called proceeding to the scene of crime or proceeding to the scene of offense by a police officer, as well as he may take the help or assistance of any forensic science experts. So investigation starts even by making an entry in the general diary or in the station diary that he has received such and such information about cognizable offense. For example, if someone is selling without license any narcotic drugs or psychotropic substance, if someone is, possessing and selling any liquor, which is, not, licensed liquor. If someone is playing, carrying out the gambling in the public places, which is not permitted. So there the police can go only by making a station diary entry and proceeding to the scene of crime. So proceeding to the scene of crime is very important point under this, CRPC, and he can proceed to the scene of crime to collect the evidence. And he can also collect the evidence with the help of the forensic science experts. There is forensic science lab van, or now we are also call it as investigation car, which is stationed at the police control room. And this car is always directed to visit the scene of crime and assist. This investigation car includes 4 types of experts or the assistant, the investigating officer. And these are, first is photographer. Photography is also a piece of evidence. When the photographer of the police department reaches the spot or scene of crime, he takes the photographs, or he also does the videography of the scene of crime, so that he will, show these photographic pictures as well as videography, not only to the judge, but to the witnesses, to the public prosecutor and senior officers at any time, what was the condition of the scene of crime when they had. So at the time of photography or videography, the first and foremost duty of any police officer is to give medical aid to the victim or injured person if he or she is lying at the scene of crime. First duty of police officer is to save the life of the injured person in the crime. And he will send this victim or injured person to the government medical officer or even to the private hospital also. Now there is a provision under CRPC, even you can send this victim to the private medical hospitals also, and he will be given the compensation or whatever is medical charges later on. But it is the duty of every registered medical practitioner to give medical aid to the victim or injured of any crime. So after that, his second duty is to protect the scene of crime or preservation of the scene of crime. But if it is raining heavily if it is, the out of his hands, that because of natural calamities, the scene of crime will not be preserved. Then he will call the forensic science expert in the van, or he will call some senior officers to collect the physical evidence which is at the scene of crime. So here, the most important and skillful job of the police officer as well as the forensic science expert begins. Because we should know the basic principles of handling the scene of crime, observation of the scene of crime. Take, for example, now I am in Maharashtra. I am at my home. I am sitting in my hall at the first floor. Here is my separate bungalow. Okay. And I have been delivering a lecture. Take, for example, there is housebreaking theft in this hall. Okay. And this is the scene of crime. Okay. If you want to visit, if a police officer or a forensic science expert is visiting my house, that is a scene of crime of my housebreaking theft, he has to keep 5 things in mind. What is the line of approach of the scene of crime? That is how the criminals or the suspects or the accused person have gone towards the house of Advocate Sambhaji Patil. Whether they have gone on foot, whether they have used the vehicle, whether it is 2-wheeler, 4-wheeler, 3-wheeler, or whether they have used any animal. If the scene of crime is isolated place, they may go on animal also, like horse, donkey, whatever it may be. But the line of approach towards the scene of crime is to be observed carefully by each and every police officer. So this is first point. Then next point of entry to this scene of crime. Say, take for example, here I am sitting in the hall now, I am delivering a lecture and I'm talking to you. Here, this hall is broken. There is window at my right side as well as left side. The point of entry to my scene of crime, that is my hall here, is the accused have come on a tree. First, they climbed up my mango tree in the bungalow premises. They have entered straightway into the gallery. They have cut the window with their hexa blade or whatever instrument they have, and they have entered into my room. This is second point. This is called point of entry, because there are 3 points of entry to my house. That is ground floor, main door, but they have not used it because I have a pet dog, and the pet dog always remains in my hall. So the criminals were aware that the house of Sambhaji Patil is, not proper safe for the theft because he is having a pet dog. So they have climbed up the mango tree. They straightway entered into the gallery and they have cut the windows and they have made. So point of entry should be observed carefully. Then third point is actual my scene of crime. Here, the offense has taken place. This my laptop or my mobile phone or some other valuables have been stolen. Now let us see at the mango tree whether there is any cloth, whether there is any mask, whether any piece of evidence is there of any accused person. Now while cutting the window, one of the accused got injured. Some blood drops have been also seen or noted at the window. Some blood drops also are noted in my hall on this table. These are also physical evidence. And while observation of this scene of crime, there are 4 types of methods. First is strip method. Another is wheel method. Another is zonal method, or the last one is clockwise or anti-clockwise. So forensic science experts as well as police officers have to play a role of which method is proper, which method should be used. Take for example, this is my hall. It is at measuring 30 feet width and 40 feet length. So this may be divided into 4 zones, and these zones should be observed carefully by the police officer. Here, the role of police officer and the staff along with him is very important. By the way, the mask of one of the accused also remained there. And I informed the police agencies that this mask does not belong to me. It may be of a criminal. Then this mask is very important because there may be saliva, there may be sweat, there may be some, smell to the mask. Even a dog scar can also track the route of the accused criminal persons to trace of the. So this mask is also important. Now here I have a glass. It is my steel glass. It is full of water. Because of some thirst, they have also taken water. They have put fingers on this steel glass. These fingers are also very useful. Fingerprints are also useful. This is also a piece of evidence. So fingerprint expert will develop the fingerprints on these articles. If there is some glass at my table, there may be some fingerprints. If the window is having also glass panels, then there may be fingerprints. So this kind of physical evidence shall be collected by a police officer along with the forensic science experts. So the observation of scene of crime and the collection of evidence at the scene of crime is important. Then again, there are 4 important points. Handling of the physical evidence. Each and every article should not be touched without wearing any hand gloves. Hand gloves are very important. A police officer or the investigative officer should always wear hand gloves. If he attempts to lift any physical clue, he should not touch without wearing hand gloves. How to lift, how to handle any physical clue or any physical evidence from the scene of crime is very important, and that is what is taught by the forensic science. The experts or the Department of Forensic Science teaches how to handle the scene of, how to collect the physical evidence, how to lift, how to pack it. Take for example, if I have to take, there is, blood-stained earth and sample controlled earth from the scene of crime. The investigating officer or the forensic science expert should not collect the blood-stained earth first of all. First of all, he should take the controlled soil or controlled earth in the packets. It should not be kept in a polythene bag because a bacterial fungus may diffuse the further examination. So it should be collected in a paper envelope. Okay. Then next, he should collect the blood-stained earth. Why it is? If I collect the blood-stained soil or earth for the first time, some particles which are attached to my finger may also involve in the controlled soil or in the controlled earth. So this is the methodology, this is the technique of how to collect evidence from the scene of crime. This is only one example. There are so many examples how to handle firearms, how to handle bullets, empty cartridges, that is also different. So like this, collection of evidence, handling of evidence, packing of the physical evidence, sealing properly, and then forwarding a letter to the forensic science laboratory or the central forensic laboratory. Because preparing some questionnaire, preparing some, questions to be asked to the forensic expert. It should be also a skill. It should be also lawful. For example, this is firearm. Okay, this is used in the commission of any crime. First of all, we have to take out the bullets. Bullets should be packed separately, whether it is pistol or whether it is revolver. Then, after sealing it properly, the questionnaire should be like this to the forensic science experts by police officer. And here, the police officer's role is very important. He should, whether police officer is, a police officer, but his appointment is he is unarmed police officer, unarmed police sub inspector. I was also recruited as unarmed police sub inspector, and armed police officers, that is central paramilitary forces. So I am not expert to give an opinion whether it is revolver, whether it is firearm. So first question will be asked to the forensic science laboratory is that whether it is a firearm or not. It may be a toy pistol. It may be any other plastic pistol. So he will be, that is FSL expert, will be the first person to give an opinion whether it is firearm or not. Second question will be whether it is in working condition, whether this pistol or revolver is in working condition. If it is in working condition, third question will be whether it is country-made revolver or factory-made revolver or of a foreign-made company. So there are three types of firearms: foreign-made, Webley, Scott, like that. And Indian ordnance factories have also some revolvers and pistols, and country-made. So this opinion will be also given by forensic science experts. Then next question will be, what is the bore of this firearm? What is the bore? Whether it is 9 mm, whether it is 7.6 mm, or whether it is .38 revolver, or whether it is .45 mm revolver. So this opinion will be given by the only ballistic experts. And next question will be asked whether there is a recent sign of or is recent signs of firing from this firearm. If there is a recent firing, there will be some carbon particles will be also decided. Then if there is empty cartridge which is found or at the scene of crime, you can ask another question, whether this empty cartridge is fired from the same pistol or same revolver. The firing pin and particular mark of the firing pin will be, most important. The ballistic expert will give opinion that there are recent signs of firing from this firearm, and the empty cartridge which was sent for examination is fired to the same revolver or same pistol. So these are 7 questions. See, this is the role of police officer. This is the role of forensic science experts in our assisting the judge to come or to find out the truth in the incident. And then again, last question may be asked, whether the bullet or the lead collected from the body of the injured person or the deceased is fired from the same bullets. This also can be opined by a ballistic expert. And if what is the entry wound, what is the exit wound, this can be also given. If sometimes bullet or the lead remains itself in the body because of some, fractures or some bones in the body, the bullet does not come out. It remains itself in the body. Like recent case of Musewala case, and one of the bullets remained in his head. It did not come out of his head. So this kind of opinion is also given by the forensic science experts, and where our role to come to the conclusion about a particular expert's opinion is decided by the questionnaire which is given or sent by the police officer. So any law enforcement agency should be trained in what kind of opinion, what kind of answers can be given by the forensic expert to prove the case beyond reasonable doubts. Beyond reasonable doubts. Because ballistic expert will give a certificate. He will give a certificate on the basis of the experiments carried by him, because he is a specially skilled person. He is having special knowledge, and his certificate may be admitted by the advocate of the accused also in certain cases. And if he has to ask any question, then he has to give the fees of his, evidence, traveling charges, TA, DA, or in the court, and then he may ask. Otherwise, take down the section. Otherwise, expert's opinion is admissible under the section 293 of the Code of Criminal Procedure. In most of the cases, CRPC section 293, expert's opinion is admissible without cross verification. Without cross verification, and I have seen 90% in 90% cases, the forensic science experts were not called in the court for the cross examination, because it is based on scientific experiments. They have given some scientific assessments. Even take for example the opinion who has given, he has expired after some time or after his retirement, but his notes prepared in the laboratory while giving this certificate, these notes or the documents will be produced by another forensic expert in the court, and on the basis of these notes, he can prove his certificate. So this kind of evidence will be proved by another expert also. So if particular expert is not, take for example, our Vilas sir had joined forensic science laboratory, Maharashtra Pune, for 2 years, and now he is now in this university after leaving his job from that FSL Pune. His certificate, his notes of particular period will be proved by the 293 of the CRPC. So every time forensic science expert is not, suppose these are the some important points. Again, the point of framing the questions and answering the question is very important. Unless and until the forensic science experts give opinion to the police officer and to the court about their questions, their queries, the evidence will not be admissible. So our role in this regard is very, very important. That is forensic science experts' role as well as, so they should go hand in hand. It does not mean that they should, give any kind of illegal assistance. No. A forensic science expert should be independent. They should be very fair. They should be very impartial, because the expert's opinion will prove the guilt of the accused beyond reasonable doubt, or if the particular person is innocent, then he will be also absolved, he will be acquitted, or he will be discharged from the offense because of the expert's opinion. In so many cases of gang rape, some innocent people are also arrested. And after the forensic science experts DNA analysis, it is noticed that the involvement of particular person or accused is no evidence is found regarding the analysis into any kind of, blood sample, samples or hair sample, nail clippings, whatever it may be. So, because after the Delhi incident, that is nearby case, that is 16th of December 2012, the law has been drastically changed. That is, there are a number of amendments under IPC, CRPC, Evidence Act, and POCSO Act. Because the definition of rape under section 375 of the IPC has been also changed from the date of 3rd February 2012. 13. A Justice Verma committee has changed this law. We are very much grateful to Justice Verma sir, who is no more, but at the age of 79, he, along with his other two colleagues, judges, have prepared these amendments within 29 days because the Lok Sabha Parliament was not in session and they have decided to bring new ordinance. And he was given a time of only 30 days. He had continuously prepared these amendments and he has totally changed the drastic changes in CRPC, IPC, and Evidence Act as well as POCSO, that is Protection of Children from Sexual Offences Act. So this role played by the law, makers is also very important. We have to keep in mind all the amendments under section CRPC. So section CRPC 53, 53A, 54, these are the sections related to the physical evidence to be collected or biological evidence, not only physical, but biological evidence to be collected by the examination of accused person. So here you have to keep in mind that the force also can be used. Force also can be used to take out these such kind of samples from the body of the accused person under section 53. Because this is not violating the provisions of Article 20 into bracket 3 of the Constitution of India. Most of the times it is misunderstood. Article 20 into bracket 3 of the Constitution of India says that no person or no one should be compelled to be a witness against himself in the court of law. To give evidence, nobody should be compelled to give evidence against himself in the court of law. But here, there is a difference between giving evidence and giving biological, samples for the examination is different. So under the section 53, 53A and 54 of the CRPC, that is Code of Criminal Procedure, it is clearly, mentioned or made a provision that examination of any accused person includes the examination of blood stains, semen, swabs in case of sexual offenses, sputum, sweat, hair samples, then pubic hair samples, fingernail clippings by the use of modern and scientific techniques, teeth mark, including DNA profiling, and voice samples to the medical practitioner as well as to the medical officer. So what is the difference between a medical practitioner and what is the difference between medical officer? So medical officer is always known as the medical person or doctor who is working in the government hospitals, whether it is central government hospital or state government hospital or run by a local authorities, that is municipality or the Jilla Parishad, Panchayat Samiti hospitals. So he is known as medical officer, and medical practitioner means the medical officer who has been registered under the under the Indian Medical Council Act, registration of Indian Medical Council Act. He may be BMS doctor, he may be BHMS doctor, but he is also called as medical practitioner. And even he has been empowered under section 53A of the Code of Criminal Procedure to take out such samples. And if the accused person is not, cooperating, is trying to avoid to take samples, a necessary force on that accused person may be used by the medical officer or his medical practitioner or his staff for the purpose of taking such samples. So these are the legal provisions, and these legal provisions are always complied by the medical officer as well as police officer, and they have to send such samples as per the mandatory provisions. So forensic science experts or the police officers have to keep in mind what are the do's and what are the don'ts while collecting and sending the information, because there are so many points. How to send, that is how to collect, that is do's, and how it should not be done, that is don'ts. And this list should be prepared. I have also a copy about this. What are the do's and don'ts? Because sometimes medical officer do not follow collecting such samples. And we have seen the case of Mr. Salman Khan. Okay, in Mumbai, when he was driving his car under the influence of alcohol, his the percentage of alcohol was more than 0.128. He should not exceed 0.50. However, he was having 128 per 100 milli. But the sample collected by the medical officer of Salman Khan's blood was not properly sealed by him. It was done by a compounder or his medical assistants. And this was the point raised by Harish Salve, Advocate Harish Salve, who has done this, sampling, who has collected blood. Though it is collected, the bottle is not sealed by the medical officers and it was not signed properly. So it was sealed by the company. So this was the only lapse, because he had taken a defense that the blood sample of another person was sealed and it was sent in the name of Salman to the forensic science expert. So this is the only lacuna from which he has been, acquitted from, even after the conviction by the session court. Now the matter is pending in the Supreme Court, whatever it may be the result. But these are the some do's and don'ts. So every department in the forensic science laboratory, it may be poison department, that is like toxicology. There are also certain do's and don'ts. And these do's and don'ts should be always kept in mind by the police officer as well as by the forensic science experts. Then biological, elements, that is serology, Department of Serology, they have also various, things to be sent for the analysis. Then DNA samples, DNA, there is also a kit. Okay, you may remember the assassination of our late Prime Minister Rajiv Gandhi on 21st of May 1991. Okay, the then SIT in charge, Dr. Karthikeyan, who was IPS officer, and he has conducted the investigation. And at that time also, the DNA samples were taken and the death of Rajiv Gandhi was proved beyond reasonable doubt. Because the parts of the body were not, found there. Only he was wearing some shoes which were foreign made Lotto shoes, and in that Lotto shoes, the parts of his foot were found as it is, and with the help of that, it was completely proved that this is the dead body of Raju. So in the year 1991, this technique was used by Indian police officers, and forensic science experts have also proved that, case beyond reasonable doubts. So these are the do's and don'ts regarding various departments and the police officers as well as forensic science experts have to keep in mind. Then they have to, handle the various types of explosives or the residues of explosives or the residues of gunshot injuries. And these gunshot injuries, these residues of explosives are to be collected by the police officer, and it should be analyzed properly by the forensic science experts in the department, in the laboratories. Then state excise and prohibition department is also there, whether it is liquor, whether it is spurious liquor, whether it is poisonous liquor, whether it is duplicate liquor, standardization can be also done. Then cybercrime forensics is another branch where you have also a lot of, career, and you have also various, challenges under this field. And then it may be also voice samples. Voice sample is also another, department where the electronics and telecommunication engineers have been appointed as the experts. Because I have forgotten to tell you who are the experts under Indian Evidence Act section 45 to 51. Experts are those persons who are having special knowledge, special skill in the field of foreign laws, arts, fine arts, or various types of arts, and science and technology. Science includes technology as well as medical science also. And the persons who have special knowledge of handwriting experts are also handwriting experts and fingerprint experts. So these 5 experts are found under section 45 to 47A. There are also electronic signature. They are also experts under this cyber forensics electronic signature. So this definition is there, and these experts have been appointed. So science includes technology, means engineers have been also appointed as expert under this, forensic science laboratory to recognize or to compare the voice samples. If someone is giving threat on phone, he is asking for ransom, or he is trying to extort money from any builder, any businessman, or any industrialist, or any other person, then the recording of voice samples may be found in the mobile phone, and his voice samples may be collected. So that is called technical analysis of the samples collected of the voice sample. How the voice sample is analyzed by the forensic experts in the forensic science laboratory? It is analyzed with the help of, vowels. Vowels, do you know vowels? A, E, I, O, U. So these are the vowels. These vowels are found in any language. If I speak in Hindi, these will be found. If I speak in English, it will be there. If I speak in Telugu language or any other Tamil language or any other language, of the world, it will be analyzed with the help of this and sound equalizers are used to analyze this. So this kind of, science has, developed to identify or to compare the. This also technique is also used in most of the corruption cases. If a public servant or any other person is demanding bribe or any, doing corrupt practices, and he is talking on phone or he is demanding the bribe, as well as in the presence of a complainant, and if it is recorded, his voice sample can be collected. So voice sample is also collected under section 53 of the CRPC, and this can be compared by the forensic science experts, and their opinion is most of the times 98.7% voice samples are totally matching. Only there is a slight difference because of some background sound. Take for example, I am now delivering lecture from my hall and the fan is going on. It may be a sound of my fan, and because of that sound of the fan, there may be some disturbance. So if any vehicle is going on, if any rush in the office is there, some conversation is going on among other people, so this may disturb to certain extent. Then there is also a department of psychology in the forensic science laboratory, and it will also assist the police officer to know the actual psychology of the suspect person, whether he is speaking lie or whether he is speaking truth. This can be judged, but the opinion of the psychiatrist or psychologist from forensic science laboratory is not admissible under Indian Evidence Act, because this is not a perfect science as per CRPC 293. So he is only giving a direction to the investigating officer. He is helpful to come to the conclusion, because there was the provision of narco analysis or the polygraph test is permissible, but this is not admissible. If the accused person or the suspect is giving consent for conducting any kind of narco analysis or even a polygraph test, then also that evidence is not admissible in Indian courts or Indian judicial system, whether it is civil court or whether it is criminal. Okay, but this may also be very useful to come to the conclusion at the end of the investigation. So I have also prepared 2 case studies, that is famous case study of Arushi Talwar case, Arushi Talwar murder case, and Hemraj Nepali murder case. Though earlier session court has convicted the Talwar couple, but later on the High Court has acquitted both of them because the case was not proved beyond reasonable doubts on the Talwars. So this is also a case which is also very important, and you can understand the role of forensic science experts, medical officer, and the investigating officer was not matching at all, because the medical officer who has conducted the post-mortem report on the body of Arushi Talwar and Hemraj Nepali were not consistent at all. They were not, logical and consistent with their opinions. So their opinion has been changed from time to time, and this has spoiled the case. Even the samples collected from the forensic science laboratory, first state forensic science laboratories gave different opinion. Later on, the investigation was handed over to the CBI. Then they have sent same samples to the Central Forensic Science Laboratories. Central Forensic Science Laboratory have given different type of opinion. And after all, there were 9 police officers who have conducted the case of, that is the investigation of Talwar. And at the end of the investigation or the concluding report or the closure report, the CBI officer has clearly given an opinion to the court that I have a reasonable doubt on the Talwars, that is the Talwar couple, for the murder of Arushi as well as Hemraj Nepal. But this is important, but I have no proof, that is scientific proof, to prove the case in the court of law. So I am sending the closure report against these two accused persons. So only suspicion is not sufficient to prove the case. We have to prove the case beyond reasonable doubts. And this is the role of the forensic science experts and the police officers, that the case should be proved beyond reasonable doubts. And this is very much important factor between the forensic experts as well as the police officers. If they have difference of opinion, then the court will also give the benefit of doubt to the accused person or to the suspected person. So we have to always keep in mind the case study of also Arush Talwar. So these are my some important points which are already discussed with you regarding this, point. However, nowadays, electronic evidence, this is also important. Electronic evidence or electronic device are used to detect and conclude cases of investigation. Your mobile phone is the most important piece of evidence. It gives a lot of information. It gives, lot of electronic evidence, and this evidence can be proved as per the provisions of Indian Evidence Act section 65B. What is electronic evidence or what is electronic record? That is any computer device or any electromagnetic device is used for any kind of photography, videography, voice recording, any kind of visuals, any kind of images, any kind of photographs are taken on the device, any email, any kind of, electronic location, GPS system location is found under the electronic devices or in the electronic devices. This can be proved by the certificate given under section 65B section of Indian Evidence Act. This can be proved in the criminal courts. So this is very important branch. CCTV footage, emails, text messages, WhatsApp messages, WhatsApp calling, call detailed records, CDRs, mobile phones, then images captured in the mobile phone, any audio clips, any video clips found in the mobile phone, then their data recovery, retrieval of data with the help of, these hard disks. So these SMS, text messages, these can be recovered, this can be proved beyond reasonable doubts in the criminal court with the help of the forensic science experts. So the role of police officer as well as the role of, forensic science experts in the collection and analysis of this kind of, evidence is very important. Even in sexual assault cases, the evidence of medical officer is also important. Medical officer's evidence is all the time important. Not only, even the DNA samples are not matching because the incident had taken 3 days before or 7 days before. And the clothes are not having any semen stains or blood stains. Even the medical injuries noticed by the medical officer on the victim of that sexual assault, then his opinion is also very important. That is also admissible. His evidence is treated as expert's evidence because he is a medical officer. And this can lead to the conviction of the. So mobile phones, laptops, computer devices, hard disks, cyber forensic crimes, and any other devices which are used as electronic and magnetic devices are always helpful in the conviction of the suspect. So you can prove this case beyond reasonable doubt. And if you are appointed in any Central Forensic Science laboratories or any state forensic science laboratories as an expert or a public servant, you are always protected under the section 197 of the Code of Criminal Procedure. If a public servant is acting in the capacity of his official duties or in the capacity of purporting of his official duties, he is protected by the provisions under section 293 of the 197 of the CRPC, because his actions are treated as actions taken in good faith. What is good faith is also defined under section 52 of the Indian Penal Code. So every public servant or any person who is, working in the private or public sectors should also keep in mind the word or definition of IPC section 52. What is good faith? Good faith means any act or any action which is taken or which is done with due care and attention, with proper attention, with due care. If any action is taken by any police officer, any public servant, or any forensic expert working in the laboratory, is always protected because he has taken all the time care. Okay. So this is the important point, which I have explained. Now I would like to interact with you because this may not be a one-way topic or one-way lecture. Now remaining 40 minutes or whatever time, I will discuss with you all types of queries. I have been teaching criminal laws to the forensic science students in Satara, where our Vilas was also our colleague. Okay, so it will be better that the experience of as a police officer, experience as also an advocate will be shared to you. So it will be better that if you ask any question regarding any point of criminal laws or any investigation.
Shri Patil ji.
Yes, sir. Thank you, sir.
Sir, your presentation is very lucid, very impressive, and your audio and video are very clear. And you have covered the entire range of issues related to forensic science.
Yes, sir.
And their limitations. Maybe that is because of your continuous learning, your combination of police service and the law.
Yes,
Usually lawyers will go to the police will go to lawyers. You don't have to go to anybody.
Yes, sir.
Sir, I have a small query.
Yes.
That is, if a document is written about 10 years back, for example, usually some people, what they do is they take an empty signed signature documents.
Yes.
And they fill up now after 10 years. And naturally, there will be some violation of whatever the problem may be. Is there any technique which can identify the backdated signature?
Yes. Handwriting experts are also there to compare the signatures. But what happens, sir, actually, after every 10 years, the signature may be a slight change.
Yes.
Because of due to age factor.
Yes.
Due to age factor. Okay. But most of the characteristics will be compared, and the opinion of handwriting expert will be given. And if the court comes to the conclusion that the handwriting expert's opinion is a probable and it is in favor of the plaintiff or in the defendant, the court will give the decision.
Okay, sir. Okay, sir.
Okay. And if you want to refer any previous document in the court, you have a lawful right under section 159 of the Indian Evidence Act.
Yes, sir.
For example, I am now retired police officer, and if I am called for any evidence in the court of law to give evidence in my previous case papers, I will refer to my original papers in the court
Okay.
as per section 159 of the Indian Evidence Act, and I will say whether it is my signature, whether it is my handwriting or not. So this can be done as per the process. So handwriting expert's opinion for any signature or any kind of handwriting is taken into consideration by the court,
Okay.
that is criminal court or civil court.
Yes, sir. Wonderful, sir. Thank you very much, sir, for
Sir.
your great webinar. We really enjoyed. Let the other people interact if they have any queries. Thank you very much, sir.
Yes.
Sir, good morning, sir. This is Dr. Acharyulu. I'm the Dean of School of Paramedical Sciences here.
Yes,
I had
sir.
a few months back, I had a bitter experience in State Bank of India because of this e-money and other things. There was a little bit of difference in my signature, sir. With this forensic sciences, is there any kind of standard mechanism so that this kind of problems can be avoided, sir? As I rightly pointed out you just now to my VCSR's query.
Sir, can you please repeat the same point, because my is a bit low.
Sir, in State Bank of India, my signature did not tally, sir, because of this e-money transaction and all. We are not using it for the past years, sir. So then I had a bitter experience with the bank authorities. Now, my request to you, sir, using your expertise,
Yes,
is there
sir.
any device for this kind of problem, sir?
Yes, sir. If the bank, authorities have not verified your signature properly, and if any transaction is done on this, doubtful, signature in the bank, transactions, you may file a complaint first towards the bank manager, that is higher authorities, that this handwriting or this particular signature does not belong to me. There is slight change or variation. And if the internal bank authorities inquiry give you reply that there is no any kind of negligence on the part of this bank or bank officers, then only you can go to the police station. First of all, you have to approach to the bank, and then you can say go to the police station that this is a fraud, this is a forged signature, this is a forged document, and the transaction done by the bank. So the police will register a case of forgery under section 467 and 471 of the Indian Penal Code, as well as Banking Regulation Act. Unless and until you register a criminal case in the police station, the bankers will not provide any document to police, because there is a Bankers and Books Evidence Act, a separate act. The bank details are not always provided to the police officer for preliminary inquiry. So it is always better to give first a complaint with the internal mechanism to the bank for inquiry, verification, and if their reply is not given in 3 months, then you can go to the police station. So 3 months time should be given to the bank authorities for their personal inquiry and verification.
Yes, sir. Sir, these days, there are some scientific techniques, sir,
Yes,
by name pattern recognition techniques.
Okay, sir.
Any two signatures are, there is an ambiguity between two signatures,
Hmm.
and these algorithms can be applied and accurately determined, sir. This is another one. It came up very recently using pattern recognition techniques.
Yes, sir, but actually in bank fraud cases, sometimes I am also not very much, conversant because I have handled only 2 or 3 cases of bank frauds.
Yes, sir.
However, I will
No, what-
advise only that bank authorities and only police authorities have powers of further investigation and comparison and come to the conclusion.
Yes, sir. What you said is exactly correct, sir. Just I pointed out only there is a technique called pattern recognition technique. That's all.
Yes, yes, yes. Okay, sir. Okay.
Thank you, sir.
Yes,
Thank you,
even,
sir.
one of my professor, he has done his PhD in verifying signature in pattern recognition by using pattern recognition technique.
Okay.
Yeah. So you might be knowing, sir, Dr. Rajesh Kumar from.
Yes, yes.
Yeah, yeah.
I know.
He has done this research work. Verifying.
Rajesh Kumar from now Aurangabad.
Yes, 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 from Aurangabad.
Yes. Any other questions?
Students, the session is open for question and answer now. If you have any question, you can directly unmute yourself and ask. If not possible, then you can simply type your question in chat box.
I have a small question, sir. Myself from Dr. Naga Jogayya, sir, head of the department at the Centurion University, sir, Bhubaneshwar campus. Sir.
Yes, sir.
Sir, when one police officer will decide this case is necessary for the forensic investigation,
Yes.
it is a judge will decide, lawyers or judge will decide, sir, or police officer only will decide. This
Which
case
case?
is
Which
on
case?
any crime case, sir. Any crime
Any
case.
crime case. Yes. Because our Indian Evidence Act has, made clear provisions which type of evidence or what type of evidence is admissible and what type of evidence is not admissible and what are the ways to make it admissible is explained in Indian Evidence Act. So as per the provisions under section, the various sections of the Indian Evidence Act, police officer has to take decision that this should be referred to the forensic science experts as it is, he is legally bound to, take opinion of the forensic science experts. For example, even it is a blood which is collected, he cannot, immediately say that it is human blood. So his first question will be whether this red colored stain is a blood or any other color. Okay. If it is a blood, whether it is a blood of human being or any animal, this will be asked. Then if it is human blood, whether it belongs to any male person or female person. Then whether it is, what is the blood group of this, what are the DNA component. So this kind of, opinion is to be proved beyond reasonable doubts in the court of law. And so the court always takes the opinion of forensic science expert. So the very word forensic has derived to assist the courts, because science includes all types of science, all branches of science. It also includes technology. So police have to depend upon the forensic science experts. As earlier I have told you, though I have handled so many firearms like revolver, pistol, AK-56 rifle, SLR rifle, but I cannot say that this is a firearm. It should be given and opined only by the forensic science expert, that is a ballistic expert. So that is why the Indian Evidence Act has legal provisions that which document is to be accepted, which document is to be admissible, which evidence is to be admitted. So some documents which are, original documents, and there is no dispute, then we do not send it for verification to the handwriting experts. Okay. Any other question?
Students, if you have any question, you can unmute yourself
Yes.
and ask.
Boris?
Sir, I am having another small doubt, sir.
Yes, sir.
Sir, in case the police officer has not written, it is not required any forensic evidence, sir. Okay, forensic examination is not required. But a judge may have a right to decide he can go for the forensic evidence, sir, other than the police officer. Because police officer is the first investigation officer, sir.
Yes, sir.
But they have not suggested is not required the forensic investigation. Because
Not,
they are not mentioned, not required for forensic investigation.
yes.
In case judge can ask, judge can order, sir, to go for the forensic examination.
In minor offenses, which are, I mean, punishment up to 3 years. Take for example, for the offenses which are, I mean, having punishment up to 3 years imprisonment. In such cases, the state, I mean, forensic science department has given guidelines that these should not be sent for the analysis. The weapons, the blood-stained clothes, or whatever it may be. In certain cases, important cases, the opinion of forensic science experts shall be taken, and it is made mandatory. Otherwise, the case will not be proved beyond reasonable doubt, because in Indian criminal justice system or Indian judicial system, we have been living in a welfare state. When any criminal case is lodged to the police station, then the main victim or the complainant's role is limited. The state, on behalf of the complainant, is filing further charge sheet, further case in the criminal court, and all the responsibility is given to the public prosecutor or the assistant public prosecutor. So it is a welfare state, and as per the guidelines of the State Forensic Science Laboratory, they have issued, I mean, such do's and don'ts, and these guidelines are followed by the police officers. Otherwise, Forensic Science Laboratory is having limited staff, limited officers, and they are already overburdened for the analysis. But the medical officer also thinks that viscera is kept, viscera is preserved after the post-mortem, and whether it is a case of poisoning or whether it is a case of any alcohol poison, it should be verified with the help of forensic experts. Then police officer is bound to send all these, I mean, material given by the medical officer to the forensic science experts. So this is the practice in India. Yes, sir, any other question?
Sir, there is one question in chat box.
Yes, sir.
There is
Read
one
out.
question in chat box.
Please read out, Chavan.
Yes, sir.
Oh,
So-
voice is a bit low.
Yeah. So Dinesh Kumar, he has asked one question. Is latent fingerprint which are found at crime scene give accuracy practically? So this is
Yes.
his question.
Yes, latent prints are, I mean, also called as chance prints, and this test can be proved beyond reasonable doubts. It can be compared because some ridges and some patterns of the fingerprints are always, I mean, analyzed with the help of new technology that is now called as it is AMBIS technology. Maharashtra government has also introduced in our department. I had my experience. I will tell my experience. I was police inspector and I was investigating a case of robbery. It was summer vacation time. During the night time, a house robbery was done by 4 accused persons, and they were so thirsty. They were so thirsty that they have taken away the glass, such kind of glass, and they have used this kind of glasses for drinking water while departing from the or leaving the home. The witness, one of the witness was very smart boy of 15 years of age. He had rushed towards one of the bathrooms, and from that bathroom, he had called the police that some, thieves or robbers have entered our house and they are beating our parents, and please come fast. So we reached there within 10 minutes. One of the accused was caught red-handed. However, 3 accused could succeed in running away to the, sugarcane field. Later on, they were, arrested, but the fingerprints collected by the police officer, all the fingerprints were totally matching. So these latent fingerprints are always useful, but this kind of exercise should be done carefully and at the same, interest, with the same interest. Otherwise, so many police officers do not think that fingerprint is useful, because sometimes fingerprints do not, found in the way in which they are required. So the latent prints should not be neglected by any forensic science experts. Yes.
Yeah. There is one more question.
Vilas, okay,
Yes.
you can conclude.
Okay, sir.
There was a good interaction. Are there any more questions?
Yes, sir. There are some questions in chat box.
If yes, you
Not
make it
clear.
last question.
Okay, sir.
Last question and conclude. Okay.
Okay, sir. Okay, sir.
Yeah. So last question is, why there is no any legal sections if boy gets raped?
Why there is no legal section?
If boy gets raped.
Oh, there is one provision. That is section 377. Unnatural.
Yeah,
Unnatural.
unnatural offense.
Unnatural sex. Okay. And if the boy is under 18 years of age, see, if the boy is under 18 years of age, and if he is used for any kind of sexual, assault or any kind of sexual pleasure, then he can file a complaint because he is victim in this case. Okay, so this provision is made under the provisions of the definition of rape, because rape is not only done only on the vagina. It can be done on anus. It can be done with mouth, and it can be done with, the last, that is mouth, anus, vagina, and 375. Let me.
Any body opening, sir. Any body.
Yes, any body. Okay, let us. A man commits rape to vagina, mouth, urethra, or anus. So this is, provision. If the boy is under 18 years of age, he is, done with such kind of, sexual assault, he can be a complaint. In our Maharashtra, in Sangli district, there's one of the, private tuition lady teacher has compelled one of the boy of 16 years. He was using that boy, so he had filed a complaint. He was arrested in this case. Okay. So section 377 and I also. Now conclude the session. It is better.
Thank you, sir. Yeah. Vilas, we conclude.
Yes, sir. So, probably my Honorable Vice Chancellor, Professor GSN Raju, would have enjoyed the entire session, sir. It's really fortunate from our side because sir has spent all the time in your talk and I actively involved in question session also. Professor GSN Raju is the internationally renowned electronics and communication professor, having produced more than 450 publications and 55 PhDs, sir. Thank you very much, sir, for spending your valuable time with us, sir. Now, I request Sri Amulya Behera Garu, the Dean of Forensic Sciences, Bhubaneshwar, on this happiest occasion, sir. Sri Behera ji.
Sir,
Aditya?
sorry is on previous meeting, sir, actually. Amulya sir is not
Sri
there,
Amulya
sir.
Nitra Behera, sir.
It's all right, Acharyulu, you conclude present vote of thanks. No.
Yes, sir.
If they have any other queries, they can be in touch with
Okay,
Sir
sir.
Patil ji.
Yes, sir. Yes, sir.
Okay.
Yes, sir. Now, I request Dr. Naga Jogayya Garu, Head of the Department of Forensic Science, Bhubaneshwar campus, to prepare formal vote of thanks to this gigantic personality.
Yeah, thank you, sir. Thank you for giving me the opportunity to make a vote of thank you, sir. First of all, I would like to thank to Sambhaji Patil, sir. Is giving a valuable lecture and really it's a very knowledgeable information regarding the police officer and judiciary system and towards the forensic science, sir. And really, we cannot miss this type of lectures anymore, sir. It's a very nice interaction. And as well as I would like to thank to our Vice Chancellor of Andhra CUTM AP campus, GSN Raju, sir, and as well as our registrar, sir, AP campus CUTM, and VC of CUTM Bhubaneshwar campus, Supriya Patnaik Madam ji, and as well as the registrar of CUTM Bhubaneshwar campus, sir. And I would like to specially thanks to Dean Dr. Acharyulu, sir, School of Applied Sciences and Paramedics. So, and as well as I would like to thank Dean Dr. Amulya, sir, for giving the opportunity to take this such a nice lecture, sir. And finally, I would like to thank Mr. Vilas, sir, for arranging such a nice interaction with the students to get them more knowledge about the various laws and enforcement agencies in a way forensic experts towards the Indian judiciary system. So this is the, and I will also would like to thank all my faculties and as well as all the students for such a nice cooperation between this whole section. And I hope you all people get a good knowledge about the various laws and various sections and various divisions related to forensic science and police and judiciary. So in this one, I am concluding my vote of thanks to all people. Thank you, sir. Thank you very much,
Thank
sir.
you,
Patel,
sir,
sir.
again.
Okay. Thank you, sir. Thank you, Sir Patil ji.
Thank you. Sir, if possible, please visit our campus, sir.
Yes, yes. I will be there.
This is a request on behalf of Centurion University of Technology Management, AP, sir.
I will take pleasure to visit your campus soon. Okay, sir.
Most welcome, sir.
Thank
Please
you.
inform.
Thank you, sir.
Thank you so much, sir. Thank you. Patil,
Please.
sir. Dhanyawad.
Ah,
Dhanyawad.
yes. Thank you.
Thank you, sir. Thank you, sir. Thank you.
Thank you very
Acharya, sir. Thank you, sir. Sir, thank you, sir. Vilas, sir. Bye, sir.
Bye bye. Thank you.
Mercy, sir.
Students, you all can leave the meet.
The
Thank
meeting.
you so much. Thank you all. Thank you, students.
Yes, yes.
Students who are having any other questions, me either Vilas sir will clarify. Don't worry.
Yeah.
Who are typed that questions, we will clarify.
Yes, yes. And we will forward same questions to Advocate Sambhaji Patil, sir. No issue.
Okay, sure, sure. Thank you. Thank you.
Thank you all. Thank you so much for joining. Bye, Naga, sir.